Several weeks ago, I went to a seminar, part of which dealt with how defense lawyers prepare for plaintiffs' depositions in employment law cases. Now, you may recall the plaintiff is the person who's bringing the lawsuit, and most of my clients are plaintiffs. And depositions are questions under oath in front of a court reporter, and everything is recorded. The deposition, as I have said in a couple of previous podcasts, is the single most important part of an employment law case. The reason for that is once a party says something under oath, that party is bound by that statement, and there is no redemption for that person. There's no document which kind of changes that answer. There's no witness which can really change that answer. If a plaintiff gets a question, why do you believe so-and-so got promoted instead of you, and the plaintiff has brought a race discrimination case, and the plaintiff says something like, they were afraid of that guy, he was a union guy, the plaintiff has significantly and seriously undermined her case. It's so important to understand the legal elements of one's case, and defense lawyers sit back and they wait till late in the afternoon to bring out some of these questions, which can be trouble if they're not handled properly. I learned that a defense lawyer, it is not uncommon for a defense lawyer to spend 40 hours preparing for a plaintiff's deposition. I mean, think about that. An entire work week is spent preparing for one of my clients' depositions by the other side. And why is that? Simply because if the plaintiff does really well at deposition and the case beats summary judgment as a result of that, the settlement value of the case will dramatically rise. Now, I'll say this. When I say defense lawyers do this, agency government lawyers do not do this. I have been at hearings, one in particular I recall last year, where the agency witness comes into the room in front of the AJ, and the agency lawyer introduces herself to that witness. And I'm thinking to myself, wow, like that's the first time you've met your client is at the hearing? Well, when there's no financial incentive for these lawyers to win or do really well, okay, they're not on any sort of contingency, they're not going to have the incentive to do well, and they're not going to do well. Defense lawyers at corporations or at big law firms who are paid by insurance companies have more than enough incentive to really get you and try to screw you at deposition. A deposition preparation should be at a minimum several hours, several times. Okay, I mean, I had a case down in Georgia recently where I had met with the plaintiff 3 times. It was before his hearing, but we went through the stuff 3 different times. And that's how the human mind remembers things, is in 3s, generally. So when you prep for your deposition, before you meet your lawyer, you should go through the stuff at a minimum of 3 times. And what is the stuff you should go through? We all know the answers to that. Anytime you have ever written an account of the events of your case, you need to study that written account, whether it's in your interrogatory responses, your federal complaint that was filed, your EEOC charge, any sort of email where you told the story over to somebody else. You absolutely have to review all of those things, and if you find inconsistencies, talk to me about it. That's the time to handle those inconsistencies is before your deposition. The time to discover there are inconsistencies is not at your deposition and certainly not at a hearing. Defense lawyer says that when he writes a motion to throw your case out, if 90% of that motion is not about what you've admitted to at deposition, he will probably lose that motion. And that's why it's extremely important that you understand the legal elements of your claim. Now, there are three general points that I want to make specific to depositions that people I have noticed kind of tend to digress into, which can undermine their case significantly. Right? The first point has to do with recalling a conversation at a deposition. Right? You are asked by the defense lawyer, can you tell me, Mr. Plaintiff, when you complained about discrimination to HR, which you say you did, take me through that conversation. Who did you complain to? What did you say? What did she say? Go through the blow-by-blow of that conversation, which is a very appropriate question because, again, the defense lawyer is looking for any sort of inconsistency about how you're reporting this conversation at deposition versus how you may have already reported it to someone else. So what some people will do is they'll start recalling the events of the conversation. And when they do that, they incorporate into those events why they said what they said or the feelings they had when they said those things. So you may get an answer that says something like, well, I remember I was so upset. I went into HR's and there was a woman, her name was Sally Brown, and Sally was the HR director. And I said, Sally, I've got to really talk about this. And something very, very bad happened to me. And I'm thinking, yeah, something really, really bad happened to me. In fact, I couldn't even sleep last night. And I was thinking about what a horrific night of sleep I had last night. And I said to Sally, I said, Sally, so-and-so called me a very bad name, referred to me as I'm Jewish, referred to me as a kike, okay? And this is terrible, and I feel really bad about this, and I'm now complaining about discrimination, and I'm sure that's what happened, and I am sure that's what happened because I would remember something like that if that happened to me. And, okay, so now I get the transcript back, right? Now, I don't know, as your lawyer, whether you told Sally that you couldn't sleep, all right, and that's how bad it was, or whether you were just thinking when you told Sally that you couldn't sleep the night before, which is important because every single one of these lines in a deposition, if it's different than something that you reported prior to, it makes a difference and it makes you look inconsistent. Because the defense lawyer is going to take that story and the defense lawyer is going to say, at deposition, ma'am, you said that you told Sally that you couldn't sleep the night before. All right, but in your trial testimony today, you're saying you never said that to Sally. All right, and it looks inconsistent and it looks contrived. So you absolutely want to just say the facts. You don't want to say how you felt about it in the middle when you're reporting about a conversation. Issue number 2, dates. People are asked all the time, when did you complain about discrimination? If you get a question that starts with the word when, the answer to that question should be a date or as close to a date that you recall. It should not be, when did I complain about discrimination? Well, I remembered I was sitting at my desk and we had just finished the Penske project, and I looked around and I knew that the Penske project was 3 weeks, and I just couldn't believe that somebody had said to me, had called me bad names after all the hard work I'd done 3 weeks ago for the last 3 weeks. All right, again, you're adding extraneous detail to a simple question. and extraneous details have the habit of becoming inconsistent with other extraneous details that you've given in some other account of the story. When did I complain about discrimination? April 15th, 2019, right? When did I complain about it? I don't recall the exact date, but it was sometime in April of 2019. That should be your answer on any question at a deposition that has to do with when. Third issue. This comes up. Very, very important to wait for your lawyer to object to a question before you start the answer. First of all, a lot of people, what they have the tendency to do is they think they know where the question's leading. They don't even wait to the end of the question. They start the answer in the middle of the question. Well, defense lawyers love that because it looks confused. And again, they're trying to show at summary judgment, this case doesn't belong in front of a jury because the person doesn't have a viable claim, and the way the person told the story at deposition, it doesn't sound like a viable claim. So not only do you want to wait till the end of the question, you want to wait to see if your lawyer objected to the question. That is a big thing. Finally, all defense lawyers at this conference said the same thing. All right, if the plaintiff does really well at deposition, they will recommend settlement before trial to their clients. I have seen this in case after case after case. I have spent countless hours with clients preparing for deposition. I've had associates doing that. It really does pay off. It really is the time to block out. Take a couple days off of work if you have to do this. Very, very important. If you do that, you will maximize your recovery.